Obviously, every senior counsel is not going to win every case because every case has a winner or loser.
Provided them the brief and went through it with them, but I didn't really... I can't say that I thought that was an amazing experience. The solution isn't always in the courts, and sometimes there's just other ways of looking at things. But
I'd like to think senior counsel do think laterally, but yeah, perhaps that's not their brief, so to speak.
sometimes people say, well, this person's a senior junior counsel. So that's, I think with counsel, there's just really two levels. You're either you're a barrister, you're also known as a junior counsel, or you're a senior counsel, which is like a silk. I think that's basically you're just one or the other, right?
Technically, that's the way it works, but there's a large area in between junior counsel, someone that may have only been practicing for a year or two, to a senior counsel who may have been practicing for 5 or 10 years or more. And then there's that counsel in between who has a lot of experience, but they're not officially a senior counsel. You need to be ratified by your peers to become a senior counsel. So not only do you need to be an effective litigator as such in most instances, but you also need to, be liked by everyone else in order to both from a professional point of view and no doubt also from a personal point of view. I'd imagine that would come into it.
Is there kind of a diamond in the rough type person who happens to have not made senior counsel but is a genius, like akin to like a savant, like the Roman J. Esquire, in that movie, I forgot what it's called. That type of person who's just, been overlooked and so on, but they're actually really good, but just overlooked and, but they're not a senior counsel, so they're a bit cheaper. I mean, is that just a TV show thing, or?
Oh, I think that probably plays out in day-to-day life too. Perhaps Roman J. Esquire's a strong example of day-to-day, the world of day-to-day counsel. But yeah, so there's quite a large group in that in-between area that have got perhaps 5 years or more experience, but they're not senior counsel, and they may offer good value for money to a lot of prospective clients.
Do you think they can go toe-to-toe with senior counsel?
I'm sure they can, but the senior counsel sort of has the gloss and, the gold lapels. I mean, perhaps that's how you can look at it, It's a bit like a prince and a king in action. The king rules the kingdom and the prince, follows what the king wants to do. That often plays out like that in court as well.
I mean, does that really mean that anyone who has senior counsel, if the other side doesn't have senior counsel, is just going to win?
Well, no, it doesn't mean they're going to win, but on average, I think that their prospects would be better.
Do you think that the only way of combating a senior counsel is to have your own senior counsel?
I think it helps, but it also depends on which senior counsel you have too. I mean, there's senior counsel that charge $5,000 a day, and there's senior counsel that charge over $20,000 a day. It often depends on the type of matter that they're running too. If you're running, as I say before, for an ASX listed company, you might be running litigation worth potentially millions or hundreds of millions of dollars versus another senior counsel who could be, working in personal injury law where your damages are generally not often over $1 million. So they may both have a similar amount of experience in their fields, but because the amount of money that's involved in the matter is relatively larger or smaller, then their fees are also relatively larger or smaller.
I mean, that's interesting, isn't it? To say, I mean, could you have like a junior barrister who can go toe-to-toe with senior counsel, someone with 2 years experience who just happens to be a genius, or is that just TV?
I'd say it's possible, but I'd say it's probably more likely to be seen on TV. I mean, it's very hard, as you know yourself, Adam, very hard to beat experience. If you've been working in an area for 10 or 20 years, it's very rare to gain enough experience within 2 years to be able to compete at the same level.
Well, that brings me to this question, which is a phenomenon that I observed working both in accounting firms and law firms. And the phenomenon was this. When people start out as graduates or young lawyers and so on and so forth, they're offered, if you do well, you might become a partner, so on and so forth. You might do really well. You might make a lot of money, so on and so forth. Work and all this stuff, and you try and put in the effort. And as the person gets more experienced, they're able to build more, produce more productive output, become more valuable to the firm, and so the firm wants them to stay and keep them. And that tension in that relationship swings. So it starts off with the graduate obviously being less useful, so they really want to impress at the firm, to reaching a level of experience where the firm sees them as valuable and wants to keep them. So the pendulum swings. But at some point in time, the pendulum actually swings back in favor of the firm again when the person reaches a certain age. Because at a certain age, if they're at a certain level and they haven't reached partner or whatever it might be, then the question is, that person didn't make it. There must be something wrong with that person. I mean, that's the assumption. And when someone's reached that point in their career, then from the firm's perspective, they have someone who's useful in producing output and that kind of thing. But the bargaining power reduces, because for them to go and get a job somewhere else, there'll always be that question of, why aren't you a partner yet? It does swing like that. And so I want to ask you this, that long-winded story comes to this. With counsel, is it the case that if someone has not made senior counsel by a certain point in time, you have the same effect of, well, why haven't you made it yet? And therefore, perhaps that person might not be very good.
I think that could apply to a degree, but I also think there are only so many senior counsel spots available. So there's only a select group of counsel are going to make that position. Perhaps that's assembled. There are a lot more partners or law firms than there are senior counsel in a relative speaking sense. So I don't necessarily agree with that entirely. It would have some validity, what you're saying, but I'd say no, not with senior counsel specifically, because there are only a select group of senior counsel positions available.
There's only allowed to be a certain number of senior counsel. You can't exceed that number.
I'm not sure what the bar rules are with respect to how many senior counsel they have, but as I understand it, it is a select group of counsel.
Yeah, I mean, that's why I'm interested to know, because, you know, there always is that question. You want to make sure you're getting value. You know, when you're running a case, and with the barrister as well, I mean, there's always going to be that question, isn't there? You seem to be enamoured by senior counsel whenever we talk about it.
Well, they have a special glow about them, I think. Having listened to one or two of them in court over the years, they certainly they sound better and they look better, and they have a glow about them which is not so prevalent amongst other counsel. Perhaps that's why they are senior counsel, or perhaps senior counsel makes them that way. I'm not too sure.
Is that glow a real glow, or is that just your adoration?
It's more of a glow I see in court. So if that person was in court, perhaps that observation could be made. Perhaps if we're walking down the street, would not be so easy.
I'm interested, you know, because I don't know how much of a difference it makes necessarily. You know, I think there are other you know, I think there are more fundamental issues with how cases are run. And what I mean by that is you need to put a certain level of effort in. Now, I don't know if people who are senior counsel would say, well, I'm a senior counsel now, and they don't put the effort in, or whether they are senior counsel because they consistently put in maximum effort. I don't know. What do you think?
I think they know the best way to go about achieving the outcome for their client, and they're very effective at achieving that outcome. So I think it's a big picture thing, and they present the case very well, so that whatever evidence their client has in their favour is well presented to the court, and the arguments in favour of their client are well made. Obviously, every senior counsel is not going to win every case because every case has a winner or loser. So if a senior counsel's on both sides, one's going to win and one's going to lose. That's just the nature of the law when it comes to litigation.
I do remember one time, I won't say who it was, and hopefully they don't remember me either, but we did have to see senior counsel one time. And that senior counsel's a judge now. Very nice person. I provided them the brief and went through it with them, but I didn't really... I can't say that I thought that was an amazing experience.
Okay, interesting.
And sometimes when it's your first experience, it colours all your other experiences. Like if I had engaged senior counsel and thought this person is a genius, then I would have said to you, well, I would have agreed with you. But I think with senior counsel, when I have spoken to them, they tend to be a bit more along the lines of, this is the result. And if it's a bad result, it's not, well, can you do something to improve the result? It's just, this is the result of what you put forward. It's usually not the result you want to hear. And that's it.
So they're foreseeing what will happen due to their experience in that area?
I suppose so. And there could be value in that. I mean, it's very expensive. But if you're looking for a solution to the problem, I don't know if they necessarily give you a solution as much as they give you what they think the result will be. The thing is with these court cases, any court case, is underlying it is a problem that needs to be solved. And, to everyone with a hammer, a problem might look like a nail. The solution isn't always in the courts. And sometimes there's just other ways of looking at things. But I don't know if and I'm not saying all of them are like this. Look, I have a very small sample size. I don't know if you necessarily I haven't experienced any lateral thinking. In fact, but to be fair, I don't generally experience lateral thinking from many lawyers. It tends to be a very uncommon thing. I don't know why that is. What's your experience there?
My view is that the best lawyers think laterally, and they think what their client needs, and they are the steps that they take if the client agrees to that course. So perhaps senior counsel doesn't become involved in those matters because the solicitor has already resolved the issue without having to go to court. He could say to the client straight away, let's settle this. It's not worth you spending $200,000 to go to court on this. You're better off settling. Perhaps you will lose a bit of money out of pocket, but at the end of the day you probably end up in a better position than if you spend the next year or two in court. So perhaps senior counsel is consulted at a later stage than the lateral thinking stage. I'd like to think senior counsel do think laterally, but perhaps that's not their brief, so to speak. Their brief is to look at a set of facts and circumstances, predict an outcome, and try and perhaps achieve an outcome as best as they can from those facts and circumstances.
I mean, let me ask you this question, because I think law can generally be distilled down to a very simple formula, which is, what are the facts, what does the law say, and therefore what's the outcome? And that's it. And obviously for the facts you need evidence and all that kind of stuff and what's included in that. And for the law you can argue what the law might be, and you mash the two together, you get an outcome. That's how I look at it. Now, do you think that senior counsel with their advocacy skills are able to turn the dial on either two elements of the formula, or do you just think my formula is wrong? If that's the case, just say.
I think the formula possibly has a few more symbols in it than the simple formula that you've put forward.
What would you say it is then?
Well, each of those components could have numerous other components. That's, I guess, it's a more complex formula than perhaps that you've summarised for us, Adam. Well, the evidence can be looked at in different ways by way of example. Some evidence might not be available or may not be understood that may be beneficial to a client's case. Senior counsel may have the insight, or a good counsel or any counsel may have the insight to see that. And there's different ways of presenting that evidence to the court. And there could be evidence from the other side which, needs to be questioned. You might need to run off and do discovery, look for background documentation that the other side is trying to not let anybody see. So there are a lot of different, components to evidence in a lot of cases, not in every case. It depends on the complexity of the case. And as to the application of the law is quite, a complex thing, and there are also laws from other jurisdictions and different cases and different perspectives on how that law should be applied to a specific set of circumstances. So I guess from a law point of view, there are a lot of different sort of angles and perspectives that one can have in different cases. Some cases are obviously more straightforward. So that's why I think there are more than just 1, 2 or 3 aspects to a case. That might be a very simplified form of it, but within those 1, 2 or 3 things, there are multiple other things which make up the larger component.
Okay.